let's go back to my example. I owe my sister €1,000. I'm the debtor, she's the creditor. I write a will then, and in it I gift her €1,000. I die, she gets the gift of the will. Equity presumes that my gift in the will was intended to satisfy the debt. What's that mean? It means my sister, the creditor, cannot, and there's a mistake in the manual, you need to correct this. Paragraph 663, third line, bottom line even, says the debtor cannot take the legacy. It's the creditor, not the debtor, it's the creditor. The creditor, the person to whom the money is owed, the creditor cannot take the legacy and sue for the debt as well. So the sister can't say, thank you very much, Ross, I'll take your €1,000 gift, and I'm going to sue your estate for the €1,000 that you owe me as well. You can't. You can't do it. You get one or the other. Now, there are a number of conditions that must be complied with in order for the doctrine of satisfaction in respect of debts by legacies to apply. And the first is, A, there at paragraph 666, that there will be no contrary intention demonstrated. This doctrine of satisfaction and the manner in which it operates, essentially, it's a presumption. It's an equitable presumption. And as you all know at this stage, even above and beyond equity and what we've covered, all presumptions in law are rebuttable. General means by rebutting a presumption is to demonstrate that there was a contrary intention. This is at paragraph 6103 there on page 94. Basically, the situation we're talking about here, and this is fairly straightforward, is that the same person is given a legacy under the will of the same amount twice. So you have a will, basically, that repeats the same gift twice. What happens? Do they take both gifts? No. Equity treats the second legacy as being merely a repetition of what was already given. You're not permitted to double portions. You're not permitted to take both gifts. However, if two gifts of the same nature were to be given in different instruments, for example, a will and a codicil, well then, yes, you are entitled to take both together. So let's say I have a will and I leave 100 grand to my sister, and then a couple of clauses down, I leave 100 grand to my sister. She doesn't take 200, according to this doctrine of satisfaction. What happened in that case was the wife instituted proceedings seeking a declaration that she was the equitable owner of a leasehold interest in a house, which was in her husband's name. And on the same day she issued her proceedings, the husband actually mortgaged the house to the plaintiff bank. And all the plaintiff bank did was check the registry of deeds, see was there any interests against it. And the Supreme Court said that's not good enough. It said the investigations that a reasonable purchaser would have made would have in fact discovered the wife's claim. So if you had engaged in such investigations that the ordinary reasonable purchaser would have done in that situation, you would have found out that the wife had a claim against the house, and therefore you would have had to have taken it subject to that claim.